Welcome to the Litigation for the Non-Litigious Company video series, a production of Womble, Carlisle, Sandridge, and Rice. I'm Sonya Pfeiffer, a business litigation attorney, and your host for a series of videos that examine ways in-house counsel, CEOs, and other executives can prepare for litigation and avoid litigation mistakes that may prove costly. With me today is Press Millen, a trial attorney at Womble, Carlisle, who has litigated numerous complex business cases involving businesses of all sizes. Press is based in Raleigh, North Carolina. He's been practicing law for more than 25 years, helping companies to prepare for and successfully defend antitrust, class action, RICO, and business litigation. In our first installment of the series, Press will explain what we mean when we say non-litigious company. He'll also carefully outline 8 pitfalls of litigation. Press, when we say non-litigious company, what do we mean?
These are companies that don't handle big litigation, and certainly not on a regular basis. They may occasionally, year in and year out, have an employment case or a case about an overdue account, but for the most part, they don't have legal departments that have large numbers of personnel who manage litigation. They don't have the internal systems for monitoring litigation. You know, some companies have legal departments of 50 or more lawyers, and a lot of those lawyers can get involved in managing litigation. Other companies, these non-litigious companies, typically have much smaller legal staffs, and they don't have individuals who are dedicated to managing litigation.
So let's talk about 8 pitfalls of litigation that you've categorized. What are these pitfalls that companies want to avoid?
Well, these are ones that I've encountered over the years. I've seen these pitfalls, and I basically categorize them into 8 different ones. 3 of them relate to costs. One of those is the obvious cost, attorney's fees. But others involve some non-obvious or hidden costs, even like expert witness fees or the costs associated with handling e-discovery. 2 of the pitfalls relate to the way law firms handle litigation. And those basically involve the way law firms staff litigation and the way law firms aren't always efficient in how they go about handling litigation and end up reinventing the wheel. One of the pitfalls concerns a hidden cost of litigation that's non-monetary. And that's the amount of time, company time, that can get burned up, particularly the time of key executives both inside and outside legal departments. And then 2 of the pitfalls are conceptual. One of them involves losing sight of the business objective of litigation. And the last one involves not learning the lessons from litigation.
So I know we'll get into specifics later, but generally speaking, what is it that you hope to do with this video series?
What we're trying to do is we're trying to describe and arm companies, potential clients, with knowledge of what these pitfalls are, and then arm them with ideas about how they can avoid these pitfalls.
Thanks for viewing this installment of Litigation for the Non-Litigious Company, a production of Womble, Carlisle, Sandridge, and Rice. We are a full-service business law firm with 11 offices from Atlanta, Georgia to Wilmington, Delaware. And we work with both regional companies in the Southeast as well as national companies. Womble Carlisle's lawyers are innovators at law. If you have questions about today's topic or related litigation topics, please feel free to contact Press Millen. You can find him at 919-755-2135. You can also reach him via email at pmillen@wcsr.com. For more information about Womble Carlisle, please visit our website, wcsr.com.